The interview.
So there is a case that has some considerable implications as it comes to union rights and union strikes that is in front of the U.S. Supreme Court, and it's actually a local story. Glacier Northwest versus the Teamsters Local 174. The U.S. Supreme Court heard oral arguments today. Joining me on the line to explain it all is Mark Mix. He's the National Right to Work Foundation president. Welcome back to the show.
Jason, good to be on with you. Thanks for the opportunity to talk about this. And yeah, not only does it have local implications, but it has national implications as well, for sure, about how union officials conduct strikes against companies that they're negotiating with. And most people probably know Glacier Northwest is a Portland concrete producer and has lots of concrete trucks that are driving around Seattle. And they were in negotiations with the Teamsters Union back in 2017. And the Teamsters Union, in order to maximize their pressure on Glacier, decided to show up a day for work, take the trucks out, get them loaded up with Portland cement, and then before they delivered the product to customers that needed it that day, they actually drove the trucks back to Glacier and left them on site there with the concrete still in there. And there was significant property damage when Glacier had to clean up this mess with all the concrete that hadn't been delivered that day. And obviously it went through the local court out there. It went to the Court of Appeals, and the Washington State Supreme Court dismissed the case, saying really there was no jurisdiction here. But the case ended up at the U.S. Supreme Court today.
Which is not easy to get in front of the U.S. Supreme Court. What is the argument? What is being decided here?
Yeah, the question is whether or not this type of behavior by a union, obviously whether it be intentional or incidental damages during a labor dispute, is protected activity. If it's protected activity, then the state has no jurisdiction over this case, and Glacier is kind of preempted from filing any kind of court action in the state because it's covered by the National Labor Relations Board. Way back in 1950, I think it was 1959, the Supreme Court ruled on a case called San Diego versus Garmin that basically gave the federal government almost absolute control over these types of issues, labor disputes and labor activity across the country, saying that states really couldn't get involved either on the criminal or civil side because basically this was going to be regulated by the National Labor Relations Board, which is the 5-member board back here in Washington that basically adjudicates labor policy. And they're going to decide whether this is protected activity or not. If it's then really Glacier's kind of preempted and blocked from doing any kind of criminal or civil actions against the Teamsters because this would be, quote, legitimate activity.
Which is terrifying.
Destroying property.
Right?
Yeah, exactly.
That is a terrifying perspective that you could potentially purposefully sabotage equipment, purposefully cause property damage that cost the company a lot of money, and pretend that is a legitimate form of protest from a union.
Exactly, Jason. And this is not the first incident of this. There was a case in 1973, a case called Enmans, E-N-M-O-N-S, that said that union officials are exempt from federal prosecution for acts of violence that they, quote, use for legitimate union objectives. And so now we're getting to the place where the state can be blocked, or a private employer can be blocked from, criminal activity under the Enmans decision, saying, well, you can't prosecute the unions because this is legitimate union activity. And then on the civil side, they're now saying that you can't go into court with a tort claim saying you destroyed $100,000 worth of my property and you're responsible for that and I can collect that. If basically the Supreme Court upholds the kind of this dismissal and sends it back to Washington State and says, okay, you guys go do it again, what's going to happen is because the National Labor Relations Board got involved and filed an unfair labor practice charge against Glacier way back when and then jumped in between the time that the Supreme Court agreed to hear the case and this oral argument saying, well, wait a minute, this is our jurisdiction. We're going to have to decide the case before anybody can do anything. But to your point, Jason, you used the right word. It's really scary about how this might work out. And again, protecting this privilege by union officials.
Is it fair to say that this is a Supreme Court, based both on today's arguments, but also just the makeup, that is more friendly to business instead of union?
Well, I don't even think this is really business. This is property. This is like property rights, yeah. Jason. And, the union wants to argue. They argued today in front of the court, this is like, if you do this, you're an activist court and you're protecting corporations and unions. And some of the prognosticators and pundits that were talking about the case, use that kind of language saying, well, you can't do this because this will be putting the finger on the scale in favor of an employer. Well, when an employer has to clean up the concrete that dried and had to be disposed of because it wasn't delivered as part of a job action, that Yeah, I don't see where that interferes with anybody except for individual property rights. And so union officials have been granted these unique privileges, starting out with that prohibition against prosecution under federal law for acts of violence that are used to achieve legitimate union objectives. But secondarily, I mean, they're the one institution that has the right to fire you, Jason, if you don't pay them a monthly fee. I mean, and they have this power to speak for you, even though you didn't ask for them or didn't vote for them and didn't want them because of their monopoly bargaining power. This is just another example of the type of privileges that union officials have. And so hopefully the court will look at it in that context, is that, look, we have gone way out of bounds when it comes to giving union officials power, allegedly to, quote, balance the scale of power between, business and labor. But ultimately, these things impinge on personal individual property rights on behalf of this business, and then individual workers' rights on behalf of their ability to associate and to speak on their own behalf under the First Amendment. So there's a bigger issue here. I'm not sure what the court's going to do. The argument today wasn't that exciting. Justice Kagan said, well, why can't a union pick a time when they can maximize their pressure on the employer, i.e. driving the trucks back onto the lot, letting the cement sit there, although they did let the trucks continue to run and the drums continue to rotate. But when you can't deliver cement, you can't let it rotate forever if you can't get it out to the place. So they had to dump it. There were damages there in the cleanup of all that and then the destruction of the property. These are real issues that ought to be considered. We'll see what the court does. I'm not optimistic that they're going to go in and change a whole lot of things. And ultimately what's going to happen – yeah, right, very narrow, Jason. And even if they do send it back to Washington's going to have to sit on it until the NLRB acts, which could take, the case was filed – the ULP was filed 4 years ago, and they decided 30 days between the writ of certiorari that allowed the grant to argue the case and then the case being argued, they decided to get in and say, oh, wait a minute, we're ruling this is a complaint, we're issuing a complaint, we now control the case. So politics has nothing to do with this, Jason, of course.
Yeah, of course
right?
not. We would never. I love the idea of basically the question from Kagan is, what's wrong with property destruction if it means unions get a leg up in debates? So it is ridiculous. We've been talking with Mark Mix from the National Right to Work Foundation, their website, nrtw.org, nrtw.org. Thank you so much for stopping by. Appreciate it.
Appreciate it, Jason. Thanks for the opportunity.
Of course.